I spent a really lovely term at Clare Hall in the fall of 2019 and managed to leave just before the pandemic hit. And I haven't been anywhere else since then. It was nice to get to know many of you while I was there, and I'm glad I got to go there while I had the chance. So thank you for being so hospitable. Um, so Doug asked if I'd speak about Priests of the Law, my book, which came out about a year and a half ago. So Priests of the Law is about a group of justices of the early common law who I argue thought of themselves as jurists of the civil law. The book looks at a group of justices working in England's central royal courts in the early and middle decades of the 13th century, and the ways in which they tried to assert that they were part of a broader European legal culture. I'm sure most of us are probably aware that there's a long history of treating the common law as a uniquely English creation, one that's very different from the civil and canon law traditions. And there's often a heavy dose of superiority in this narrative, right? It's not just about claiming that the common law is different, but also that it's superior, more conducive to liberty, or more responsive to change over time, or something like that. To counteract that narrative of the common law's superiority, scholars have looked for signs of civilian influence on the early common law to show that the common law wasn't so insular as it's often claimed to be. And Priests of the Law is definitely within that tradition of scholarship. But it looks at the issue of connections between the common law and the civil law in a little bit different way. Scholars who have tried to show connections between the early common law and the civil law I have mostly focused on the borrowing of particular rules and doctrines, and have tried to show that the early common law might have borrowed from Roman and canon law. In most cases, though, I don't think the connections are all that clear. In fact, when it comes to rules and doctrines, there's clearly something to the idea that the early common law largely developed along its own lines. In fact, in the area of land law, I argue in the book that the justices I'm writing about tried to reconcile English land law with the Roman law of property, but found it very difficult to reconcile the rules, doctrines, and even basic concepts of Roman law with the common law, suggesting that the two traditions were already quite distinct. So I take a somewhat different tack in Priests of the Law. I don't look so much for borrowings of rules and doctrines. I look at how the civil law influenced the way these justices thought about their work in the royal courts. Roman law, I think, offered them less a storehouse of good doctrine to copy than a lens through which to view the work they were already doing, and a way of thinking about themselves and their place in the realm. The book is about the justices who wrote the treatise on the laws and customs of England, which we generally call Bracton. And Bracton is one of the central pieces of evidence I use in the book. Bracton has, as I'm sure you all know, achieved a reputation as one of the great treatises of the early common law. It still has some currency in the United States. Most lawyers here have at least heard of it because it's cited in the classic New York case Pearson versus Post, which is often the first case American law students read in their first year property course. And it's cited by the Supreme Court of the United States about every other year. So Bracton's sort of part of the canon of common law texts. And because it's one of the earliest treatises on the common law, Bracton has attracted quite a bit of scholarly attention from historians of medieval law. And a number of scholars have worked to advance our understanding of the treatise. We now have a better understanding of the timeline of the treatise's writing, for instance. So here we go. Bracton was written and rewritten between the 1220s and the 1260s. The treatise was traditionally attributed to the Justice Henry of Bracton. That's where it gets its name. We're pretty sure now that he was only the last person to work on it, or maybe not even the last, but the last in this particular line of justices probably to work on it. He probably got the unfinished treatise from William of Raleigh, a very important justice of the mid-13th century. Bracton had been his clerk, and Raleigh seems to have written large parts of the treatise and may have even been the primary author. It's also possible that it had been passed off to Raleigh by Martin of Padishal, a really important justice in the years immediately after Magna Carta. Raleigh had been Padishal's clerk. We don't really know whether Padishal worked on it or not. Paul Brand, who I saw is here, has pointed to some circumstantial evidence in the treatise that Padishal may have been one of the authors. And there may have been other people who worked on it who we don't know about. But the treatise seems to have been passed around this small group of justices and clerks in the early and middle decades of the 13th century. There's been a lot of really excellent scholarship on Bracton. When I started reading historians on Bracton, I saw a lot of very good discussion of when it was written, who wrote it, what sources they used, and whether it accurately represents practice in the royal courts of the 13th century. And those are important questions, and I couldn't have written the book without the work done by other scholars on the dating and sources of the Bracton Treatise. But I was puzzled by a lack of discussion of what I thought was the really big question. Why did anyone think it was a good idea to write this book? I think scholars have largely taken it for granted that they know what a treatise is and why people write them when they deal with Bracton. But writing a treatise about the royal courts wasn't a terribly obvious thing for a busy justice to do in this period. The Bracton authors had precedents. At least one other text that could be described as a treatise on the king's courts existed, the text known as Glanville, written in the last decades of the 12th century. And Glanville was an ambitious text in its own way, but it's a much shorter text than Bracton. Bracton is roughly the length of 9 or 10 Glanvilles. So when we start to think about writing a massive treatise, not as a natural choice, but as a fairly strange one, we can start to look at Bracton as a cultural artifact and ask what role it played in the culture of 13th century justices and clerks of the royal courts. Why was it important to these justices to write a text like this? So I'm interested in Bracton not so much for its own sake as I am for what it can tell us about the people who were working in the king's courts of the 13th century, or at least a small group of them. And I think their desire to spend their spare hours writing a massive treatise can tell us a lot about these justices and how they thought about what it meant to be a justice in the king's courts. Bracton provides us with internal clues as to what its authors were trying to do. Scholars have long recognized that Bracton makes extensive use of Roman law, as well as some use of canon law. I'm not sure that the use it makes of Roman and canon law has been well understood, though. Scholars have tended to emphasize the ways in which the authors of the treatise use Roman and canon law to fill gaps in the nascent common law, or to try to reform the common law to bring it into line with the rules of Roman and canon law. I think what we actually see in Bracton is a group of justices trying to prove that the work they're doing in the king's courts is already consistent with Roman and canon law, and that common law can be understood as a kind of civil law. And I think they were doing this because Roman and canon law had quite a bit of prestige in the 13th century. Many people thought of them as the two universal laws of Christendom. And there was a community of jurists who studied and practiced Roman and canon law throughout Latin Christendom. The authors of Bracton had read works written by scholars from Spain and Italy, for instance. And I think they wanted to imagine themselves as part of that community, to think of themselves as jurists of this universal law. So first, I'm going to talk about the ways in which they use legal doctrine to make this point. The authors of Bracton worked hard to reconcile the rules of Roman law with the rules they were applying in the English royal courts. There's a lot of Roman law in Bracton, a lot of Roman law terminology, Roman law doctrine, and citations to texts of Roman law. But I don't think that the authors of Bracton primarily use the Roman law to fill gaps or to propose reforms, although there are examples of each of those. Generally, I think their purpose in using Roman law was to demonstrate that the work they were doing in the king's courts was already in harmony with the rules of Roman law. Here it's interesting to note what happens when rules of Roman law and the practices of the English courts actually conflict. The authors generally don't try to change English law to fit with Roman law. Instead, they take English law as a given. They take the practices of the king's courts as a given and go to great lengths to show that it's in accord, those practices are in accord with Roman law, even when they can't quite make that work. So to give an example I discuss in the book, a major issue, which the authors come back to again and again throughout the treatise, is how to explain English land law in terms of the Roman distinction between property and possession, one of the most important distinctions in Roman law. Property or ownership is different from possession. One person might be the owner of a thing, and another might be in possession. And Roman law had separate actions for recovering possession and for vindicating one's ownership rights. The English courts, on the other hand, didn't use a binary distinction like this. They used a hierarchy of writs. So this is often how the treatise authors discuss the hierarchy of writs. They use a bunch of different writs for recovery of land, but they exist in a multi-tiered hierarchy. A hierarchy that the Bracton authors discuss several times throughout the treatise, and they explain the principle that a person who's already brought a higher writ in the king's courts is thereafter barred from bringing a writ lower in the hierarchy in the same dispute. So one issue the Bracton authors were faced with was, how do we express this hierarchy of writs in terms of a binary of ownership and possession? And they really do seem to want to do this, right? They think of the hierarchy as something that they should be able to map on to that binary of ownership and possession. And so they created several different schemes for reconciling these things. And I'm not going to go into great detail here. If you're interested, you can read about these schemes in the book. But these schemes are fascinating in that they actually contradict each other. The authors will use the words possessio or dominium in different and contradictory ways, depending on the context, depending on the way they're trying to reconcile ownership and possession on the one hand with the hierarchy of writs on the other. So the authors couldn't quite make these Roman categories fit neatly with English practice. But it seems to have been important to the Bracton authors that they not misrepresent the law as practiced in England's courts. And the circumlocutions they go through to ensure that they don't actually misrepresent what would happen in the royal courts could be described as heroic, right? When they deal with this particular issue of how you map ownership and possession onto the hierarchy of writs. So first, you have the attempt to explain the rules the justices are already applying in the king's courts in Roman law terms. Second, these justices tried to show that the common law was part of a broader Roman law world by writing the kinds of text a jurist of the civil law would write. The Bracton authors probably didn't think of Roman law as only or even primarily a body of substantive rules. When they thought about Roman law, they probably also thought of a particular set of practices. We can be fairly certain from Bracton itself that at least some of its authors had had formal training in Roman law. And that training would have encouraged them to think of Roman law as a textual practice. So the cover image for Priests of the Law actually illustrates this point very well. It comes from a 13th century manuscript of Justinian's Digest. And this manuscript is actually owned by Gonville and Caius College. And I visited Gonville and Caius to look at some of their statute books while I was in Cambridge, and I am now kicking myself that I didn't ask to see this manuscript. It just didn't occur to me at the time. So I've never actually seen the manuscript, but maybe someday I'll get back there and see the manuscript. In the image, a doctor of law sits with the text of the digest in front of him while his students all follow along in another copy of the digest. Learning exercises in the universities revolved around authoritative texts like the digest, and jurists were defined by the types of texts they produced. The authors of Bracton, working in England, were probably particularly inclined to associate jurists with the types of texts they produced, because these English justices encountered the great jurists in Bologna or elsewhere in Latin Christendom, not through their teaching, but through texts that had made their way to England through networks of scholars. They would have known important jurists like Azzo, Tancred, and Raymond of Peñafort, who are all referenced in the treatise in some way, primarily as producers of texts. These English justices tried to show that the texts they produced were actually very similar to the types of texts a jurist would produce. So one element of this was the Bracton Treatise itself. It's written in the form of a summa, which is a type of text a jurist would write. And Bracton is modeled in many respects on the summae written by Azzo of Bologna, famous scholar of Roman law in the first decade of the 13th century. So Bracton itself is a statement about the work of the justice. These justices are writing the kind of text a jurist of Roman law would produce. But they did something more interesting than that. They didn't just produce new types of texts. They took the texts they were already creating in the king's courts, their court records, and started reading and writing them in new ways to assimilate them to genres of legal texts they had encountered in their study of Roman law. So these justices in various ways tried to show that the texts they were already producing as part of their work in the royal courts were analogous to the types of texts jurists produced. In the royal courts, justices and their clerks wrote plea rolls, which were records of the cases they had heard. The justices who wrote Bracton tried to imbue what were essentially administrative records, they're records of cases or records of stages in procedure, right, in the cases. They tried to imbue these records with attributes of some of the texts they'd encountered in their study of Roman law. They treated them as texts that didn't simply record steps in litigation, but that contained profound statements of law. And they could be cited as texts of authority, alongside texts from Justinian's Digest. There's a surviving collection of cases drawn from the plea rolls that was produced by this circle of justices, a manuscript that Maitland dubbed Bracton's Notebook. Bracton's Notebook is a collection of about 2,000 cases decided in the king's courts between 1217 and 1240. And it was almost certainly made by the same circle that produced Bracton. This was a massive project that must have taken a great deal of time. Selecting 2,000 entries from the plea rolls out of tens of thousands on those rolls and copying them into a book. So this project must have been important to the justices who undertook it. And the notebook was probably not the only such collection made by this group of justices. In fact, the notebook is probably just the tip of an iceberg. It was likely copied from at least 2, but possibly as many as 5 prior collections of cases. And I make the argument in an appendix to the book that these collections of cases were being made at important points in William of Raleigh's career, that the breaks in the text line up with important points in Raleigh's career. So these justices were working on this case collecting project at the same time they were working on Bracton. In Bracton's notebook, we can actually see these justices attempting to turn the plea roll entry into a type of legal literature. Administrative records of actual cases, created so the court would have a memory of its own process, are transformed into abstract statements of legal principle in the notebook. The creators of the notebook often remove information important to the case, names and dates, for instance, because they're interested in the case as a fact pattern, not as a record of an actual case. My favorite example of this is a case from a plea roll of 1223. The action was brought by a writ of customs and services, where a lord is claiming that his tenants owe him certain services. And the entry on the plea roll describes the services at issue in detail. The notebook omits them, and the omission was deliberate. On the roll, there's a mark next to this case to mark it for copying, and a note that says loquator mecum de hoc capitulo. He should speak with me concerning this chapter. So the person who was marking cases for copying, who was actually probably Henry of Bracton in this part of the notebook, presumably had a conversation with the copyist and said, cut the customs and services, we don't need them. This is even more interesting because in his edition of the notebook, Maitland drops a footnote that says, the notebook does not describe the services, but they are so interesting that I supply them from the roll within brackets. He then goes on to include a substantial selection that describes these customs in detail. So the part that was of interest to Maitland, the historian, and presumably also to the lord who was claiming his services, was of absolutely no interest to Bracton. That's the part he wanted cut. So the case was probably of interest because it had some interesting procedure in it. So it seems like it was interesting to Bracton primarily for the law it contains. We also see this in the marginal glosses to the notebook. These glosses often reduce the case to a pithy statement of law that can be applied to other cases. Note that a gift without season has no force where the donor died seized is one example. These practices of cutting out case-specific material and of glossing bear some resemblance to practices current in canon law. Jurists were collecting decretals around the same time, papal letters that gave instructions to an ecclesiastical judge on how to decide a particular case. And they were placing them in collections so they could use them as general statements of the law of the church. It's possible, I think it's just possible that the Bracton authors were even inspired by decretal collections to think of their plea rolls as a possible place to look for legal principle. If you look at the decretal collection known as Compilatio Tertia, which is made between 1209 and 1210, and was probably circulating in England. They probably, would have been able to access this collection. It says in the very beginning that the decretals in it were collected from the papal registers, so that might have given them some, that might have been an inspiration. I can't really say one way or the other, but so this is all just suggestive. And I don't want to make any direct equation of the notebook with the decretal collections. There are significant differences between them. But I think there are non-trivial similarities in the ways the decretal collectors and the authors of the notebook treated the texts they were collecting. Decretal collectors often removed case-specific information, such as place names and names of parties, in the process of copying these decretals into the collections, just like the authors of the notebook did. The decretal collections were then glossed, although admittedly, texts such as the decretals of Gregory IX were glossed much more heavily than the notebook was. The glosses are really just sort of occasional in the notebook. They're not like the glosses that you see taking up the full margin of the page in a decretal collection. But the notebook shows us, at the very least, that its creators and the decretal collectors were thinking about their texts in parallel ways, in the sense that these were texts that were specific to particular cases that were being excerpted from administrative records to serve as sources of generally applicable law. So the notebook provides us with some indirect evidence that the justices who wrote Bracton thought about plea roll entries as analogous to the kinds of texts they had encountered in their study of Roman and Canon law. In Bracton, we find an even more direct equation of the plea roll entry with genres of text current in Roman and Canon law. Bracton contains more than 500 citations to cases from the plea rolls. It doesn't contain transcripts of the entries like the notebook does. It just contains citations to the cases. And it treats these texts as if they're analogous to the authoritative texts of Roman law. The introduction to the treatise appears to discuss the process of collecting these cases from the rolls. When it says, "I have turned my mind to the ancient judgments of the just, examining diligently, not without working long into the night watches, their facta, consilia, and responsa." The quote is actually a reworked version of something the jurist Azo wrote about the Emperor Justinian when he was collecting the opinions of the great jurists to include in the digest. So you see this here. There's some parallels in the construction here, right? After Justinian commissioned the Codex, he turned his mind to the immense volumes of ancient wisdom, meaning treatises written by Roman jurists of the classical era, which ended up being the source material for the digest. These kind of excerpts from works of Roman jurists. The author of this passage in Bracton changed some things. He put himself in the place of Justinian, which may have been a bit presumptuous, maybe even blasphemous, right? So author is putting himself in the place of Justinian. Immense volumes of ancient wisdom becomes ancient judgments of the just, which is an interesting move. Because on the one hand, the word judgments, judicia, is the word that was used in the English courts to refer to decisions in individual cases. And most scholars who have examined Bracton have taken this word to be referring to the cases cited in the treatise, those 500 or so cases drawn from the plea rolls. And I think in a sense that's probably right. That probably is what the author's talking about here as his source material. He's talking about the case citations. But judicio was also used in civilian circles to mean opinions of jurists. And the words consilia and responsa that appear just after it were terms for a genre of literature that was current in Roman and Canon law, where a jurist gave his opinion on a thorny point of law. We actually find judicia and responsa used together in a very similar way in a series of lectures on the institutes given in England sometime around the year 1200. So in a discussion of the responsa prudentium, one of the sources of law listed in the institutes, this lecturer on the institutes says that jurists could give answers and that no judge should be allowed to go against their judiciis, that is, their responses. So I think the Bracton authors may have been playing with the meaning of judicii here. The judgments issued by the justices in the English courts are also, in a sense, jurists' opinions. And that's certainly the way the authors treat these citations to English cases throughout the treatise. In fact, they treat them as if they have similar authority to the opinions of jurists found in Justinian's digest, that source material of the digest. Scholars of Roman and canon law in the 13th century placed a heavy emphasis on the harmony of their systems of law. And one of the goals of 12th and 13th century scholarship was to reconcile texts that appeared to conflict with each other. Gratian's Decretum, that important textbook of canon law, was titled in full the Concordia Discordantium Canonum, the harmony of discordant canons. Gratian took seemingly contradictory decrees of councils and popes, along with some statements of the church fathers and other texts, and not only placed them beside each other, but also offered solutions to the apparent contradictions between them. You find this emphasis on harmony in Roman law as well. An imperial constitution, appended to the beginning of Justinian's Digest, gave this advice to the reader. As for any contradiction occurring in this book, none such is found a place for itself, and none will be discovered by anyone who reflects upon the modes of diversity with a subtle mind. On the contrary, something will be found, even if obscurely expressed, which removes the objection of inconsistency, gives the matter a different aspect, and passes outside the limits of discord. In this constitution, Justinian essentially gives his marching orders to jurists, right? If any of the texts contained in this book appear to contradict each other, figure out a way to reconcile them, right? Think harder. They don't actually contradict each other. And this is what a lot of the scholarship produced in the schools looked like. It was intended to reconcile authoritative texts that appeared to conflict with each other. Bracton contains citations to primary texts of Roman and canon law, mostly provisions of Justinian's Digest, but also the Codex, the Decretum, and the Decretals. And there are some passages where the Bracton authors actually work to try to reconcile texts of Roman law that appear to conflict with each other. A bit odd in the context of a treatise on English law, right? But they do it. What's even more interesting is that the authors of Bracton occasionally try to reconcile the authoritative texts of Roman law with cases decided in the English courts. So this is one of my favorite passages in Bracton, and I will mercifully refrain from reading it all aloud. It's a bit of text that was probably added by Henry of Bracton late in the process of editing the treatise. And Bracton starts off by reconciling some texts of Roman law that appear to conflict with each other. Thorne modernized the citations in his English translation, and I've left them like that. You can see them in gold here. This discussion of the Roman law texts is partly borrowed from the Summa Aurea, a treatise by an Oxford canonist named William of Drogheda. And Bracton may have actually known him. It's possible that they knew each other. They were contemporaries. It's not completely borrowed, though. Bracton actually seems to do some new things here. So I think he's applying what he learned in the schools, right? He's applying this method of reconciliation. Now, after these citations to the Digest and Codex, he throws in this case between the Abbot of Rievaulx and Peter of Savoy in the Court Quorum Rege. And that case is cited in the same way the provisions of the Digest and Codex are, as an authority in the same sort of way. And then he keeps going with citations to Roman and canon law after this. Bracton seems to have thought that the cases cited in the treatise were part of the same textual universe as the provisions of the Digest and Codex. So I think these justices were doing with the records of the royal courts what they did with the substantive law of the royal courts. They're not changing how they write these texts exactly. They're trying to convince the reader that these texts are already like the texts of Roman and canon law, and that the practices of textual production that justices and clerks engage in, such as writing plea rolls, are analogous to the types of textual practices that jurists engage in. Although I unfortunately don't have time to go into the details, I think Henry of Bracton took the message that plea roll entries were the equivalent of jurists' opinions to heart. We have some of his plea rolls from the 1250s, and in one chapter I argue that we can see him editing them to make better law. I think he was hoping someone would cite his own plea rolls for the law they contained, and not simply read them as administrative records. But you can read about that in the book if you're interested. So why did these justices spend the hours and hours it must have taken to create a literature of the English courts on the Roman law model? Well, I think one purpose of these textual practices was to create a sense of meaning for the kind of work justices did. Roman law, in a sense, provided the authors of Bracton with a prepackaged identity, the learned jurist. And these practices allowed the justices and clerks of the royal courts to imagine themselves as part of a cosmopolitan learned community of jurists that spanned Latin Christendom. Paschal, Raleigh, and Bracton were essentially a new type of justice. They were career justices. All three seem to have begun their careers in the royal courts as judicial clerks and served long apprenticeships in that role before ascending the bench. They spent their entire careers working in the king's courts, and most of their time at any given point in that career working in the king's courts. They were not, for the most part, engaged in other types of royal service. There are exceptions to this, as earlier justices of the royal courts had been. So in a sense, we might call them professional justices. That's a term that carries a lot of baggage and can imply a number of things, such as some kind of institutional organization, like a state bar today. I'm using it in a limited sense. These are justices who are professionals in the sense that they specialized in this type of work, and this type of work specifically. And I think Paschal, Raleigh, and Bracton can be described as professionals in another sense as well. I think they perceived themselves primarily as people who worked with law. Their work in the royal courts was probably a source of identity for them, in a way it had not been for justices of earlier generations. And I think we can see that in Bracton and other texts they produced. That career justice was a new figure in the early 13th century, and there was no obvious or predetermined template for thinking about a career justice. The kind of authority he had, the level of prestige he should enjoy, his place in the realm, those kinds of things. There were different templates available. So justices like Ralph Hereng, who acted as estate stewards earlier in their careers, might have seen their work for the king through that lens. There were strong parallels. It was not hard to draw parallels between those types of work. In addition to looking after their lord's land and his interests, stewards often held the lord's courts. And in addition to keeping the king's courts, a royal justice sent on air had responsibility for looking after the king's interests. Many of the articles of the heir concerned royal officials or royal rights in the county. So it wouldn't have been difficult to make this connection between the work a steward did and the work a justice did. You could think of yourself just as a type of steward for the king, right, if you were a royal justice. But I think Paschal, Raleigh, and Bracton set out to write Bracton because they were drawn to a different template. We know from their writing in the treatise and from their plea rolls that Paschal, Raleigh, and Bracton probably had some knowledge, at least some of them, right? At least one of them, I guess, had some training in Roman law. Although the Roman law terminology appears it's so fundamental to so many parts of the treatise that I think it must have been there in the earliest stages of writing. I think it really was part of the project from the beginning. Bracton, I think, was particularly attracted to Roman law models, but I think it was part of the vision from the beginning. So they had probably studied in the schools somewhere, right, before they entered the courts. And in the schools, they would have been exposed to a particular vision of law and to a particular vision of who the law's heroes were, the jurists. They seem to have taken two lessons from their time in the schools. First, that law was at least partly a textual practice, which wasn't a foregone conclusion in the 13th century. And second, and corollary to the first, that the way to be a jurist was to write like a jurist. The jurist was characterized as a person who wrote particular types of texts. So these justices, I think, were looking for a way to think about who they were, and they found it in the texts of Roman law. The justices who wrote Bracton didn't think that the law applied in the English royal courts was superior to Roman civil law, and I don't think they would have approved of the notion that English common law was exceptional. These justices, on the contrary, worked hard to demonstrate that their work could be understood through the lens of Roman law, that the common law was just one part of a broader civil law culture. They weren't simply servants of the English king, right? That's the point they wanted to get across. They were priests of the universal law of Latin Christendom. That's all I have, so I'm happy to take questions.
Thank you so much, Professor McSweeney. That was very thought-provoking and absolutely fantastic. We will go ahead and open up for questions if anybody has any. And while people are considering, I will go ahead and get started. I did want to ask about to what extent this model was exported as well as the influences imported from the schools, as you mentioned, on the continent. Is there any indication that this new model that was being developed by these justices in the 13th century had an influence outside of England, or perhaps led some others to see juris in the same light?
Well, I don't think Bracton has any influence outside of England, and in that. So Bracton, in fact, I think in this sense, like in some ways, I think this is sort of the road not taken, right? That this jurist, this sort of jurist model that the Bracton authors are pushing is one that does not end up winning out in the end. People are reading Bracton at the end of the 13th century, and that's actually one of the mysteries. I want to work on this some more, but why people started copying Bracton in such, like, the copies of Bracton are all from the end of the century, right? When really, I think, these people and their vision of what the royal court should be like has pretty much died out by then, right? That they're not, it's the path that didn't end up being taken. So I don't think it, in a way, like, I don't think, in terms of, like, are they influencing anybody? So on the one hand, I don't think they're influencing anything outside of England. On the other hand, I'm not sure they're influencing that much in England, and I'm not necessarily sure whether they intended to, whether, I'm sure they would have liked their vision to be adopted in the English royal courts. I think there's probably a sense in which the people they're writing to convince are themselves, like, to a large extent, that they may not be writing to convince any, they may not have a large audience in mind or anything like that. In fact, I make this argument in the book that if you think about the group of people they're writing to, right, that this treatise is addressed to justices and clerks of the royal courts. In various ways, you see that in the treatise. The justices and clerks are the only people the treatise addresses directly. You would be hard pressed to, like, if this was your only text about 13th century English law, you probably wouldn't be able to figure out there were lawyers in the royal courts in the 13th century, right? You would never know from reading Bracton. You would have to really read between the lines to figure that out. So I think they had a very, in one way, they had a very narrow view of their audience, right? That this was a small group of people they were trying to reach. And so I think it was kind of internal looking in a lot of ways, right? That this is them trying to convince themselves that we're jurists that write themselves into this story of this broader story of the civil law.
Sure. John Hudson.
Tom, the question of consilia and extraction from cases.
Mm-hmm.
This sort of extraction from cases is going on in lots of places. There's the set of judgments from the Norman Exchequer that Delisle edited and no one seems to read. Now, the various possibilities here. One is that the same sort of influence is existing in various places, or that the sort of influence from Roman and canon law that you're suggesting applies in England and not elsewhere. Or it could be that people are keen on abstracting from cases for a variety of reasons independently of Roman and canon law. How strong do you think the argument for influence of process really is?
Yeah, so this is a good question, because you're right, and I do discuss this a little bit in the book, that there were other people collecting cases in England, and we don't know what they were doing with them or what their motivations were. And then you have the Norman tradition. There's even, I think there's even some possibility there's some odd similarities in phrasing between what you find in Bracton in reference to the cases decided by Martin of Padishal, and the Très Ancien Coutumier, and what the I've forgotten the name of the official now, but what he used to say and do, right?
William of Seneschal.
Yeah, that's right. It was William de Longchamp. What he used to say and do, right, are referenced in both of those. And so I think, I think it's probably, there probably are people. I don't think that Roman and canon law are probably the thing that's influencing everybody to collect cases. In some ways, collecting cases is a fairly obvious thing to do, right? If you want to know what's going on in the king's courts, and you want to know what's going to be an effective argument, or what we should do next time, right? Collecting cases makes a certain amount of sense. You know what they've done before, right? I think, yeah, I think that there are probably a lot of people who are independently coming to the same conclusion that collecting cases is a good idea. I think in the Bracton case, we can see evidence that they're at least, even if it's not the original inspiration for them, right? That it's at least they're imbuing it with a different kind of meaning because of their contacts with Roman and canon law.
Great.
I will apologize if I butcher this pronunciation, but Lucas?
Thanks very much. I have two comments. The first one is connected with the subject which was already a little bit discussed here, and it is how far, or is it possible that Bracton influenced the continental literature? And my thinking here is that when we will compare Bracton and the works which were created in the sphere of the Roman and canon law in the continental Europe, we will notice quite clearly that it is a very different method, because this is the time when the Roman and canon law is produced in the there's the glossa approach, which is not seen in the Bracton. But when we will look at the post-glossators, we will suddenly understand that their way of writing about the law is very close to this what we can find in Bracton, and the post-glossators is 14th century, so 100 years after Bracton. So I don't know. I'm not trying to say that Bracton influenced Italian jurists in 14th century, but I think there is certain similarity, and maybe this is an interesting topic here. And my another comment is, you said, you made this very clear difference between the Roman law, between the ownership and possession, and about the writs. And I think it is, of course, it is true, but I'm not sure how much 13th century lawyers, and I mean here not only authors of Bracton, but also Roman and canon lawyers, were aware of that. But I think we have to remember that the Romans were thinking, like the English jurists lawyers in the medieval England, they were thinking about the law through the lenses of the procedure. And even if they are using in the digest the terms ownership and possession, in fact, the most important subject for them is how to acquire ownership and possession, and how to defend the ownership and possession if anyone wants to stole this from us or things like this. So I think there are certain similarities. It is true that from the terminological point of view, there's a difference, but I think this difference is connected also with the fact that in the digest we have the experience of the late Roman law, but if we will look much closer to those texts, we will see that these are in fact classical texts, and the classical jurists were thinking very much like the medieval English lawyers. So these are my comments. Thanks.
Yeah, so that's interesting on the post-glossators point. Yeah, and I'm not I'm not sure I could speak intelligently on, like, if there I doubt there's any connection between them, because Bracton just doesn't seem to have any influence outside, unless it's what we're seeing is sort of educational methods that are already in place but don't end up being kind of put down in writing until later or something like that. I think they are following Azo, but you're right with the kind of the glosses. The glosses that you find in the notebook aren't part of at least they don't seem to be the product of some kind of intense teaching process, right? That you would like you would see with Roman law. They're just sort of little pithy notes on the side, right? That somebody's included. So they actually probably come from their reading of text than that kind of educational practice. Yeah, and on the kind of procedural aspect of Roman law thinking in terms of procedure, I think that's a good point. That the Roman jurists were thinking in terms of actions and how ownership and possession would have fit into actions. I think the Bracton authors, though, like the kinds of things that they try to the things that they try to do to ownership and possession to make them fit into this system. There's a passage, I don't have a slide for it, but where they talk about each writ having some amount of ownership and some amount of possession. This writ, so the person who has much of, or no, sorry, it's possession and right in that case, which becomes a more important distinction later in the common law. But they talk about a person who has much of possession and much of right, and then some people who have much of possession but little of right, and things like that. And then they throw dominium into this system somewhere, and so it's, I think they come up with schemes that I think to a Roman lawyer would have just been wacky, that wouldn't have been recognizable to somebody who worked in the schools, even if they are thinking in ways that are not completely alien to sort of the Roman law thinking about actions.
Sarah?
First, I just wanted to say, Tom, I so enjoyed listening to you talk about your book. Really, really lovely stuff.
Thanks, Sarah.
I also think that you are the only person I know who actually has a favorite passage from Bracton, which
Well,
I know, I wish I could say that myself. I'm really excited about the way you are finding these this cooperation between Roman law and common law. I think for too long we've had this sense that common law is something exceptional, and I think it's important to recognize that jurists in this period didn't necessarily want to be exceptional. They wanted to be part of an establishment. And I love the fact that you're coming at this through identity. I think this makes sense of it all. And I'm just wondering, did natural law help with this at all? Because everything fits in eventually to natural law, right?
So this is a good question. They do now. Whether they now, I'm not sure. I'm trying to think now. I have to admit I did not get into like the natural law debates when I was writing, when I was writing this. So there are ways in which I'm trying to remember now if they discuss natural law in this way, because they do discuss say the use gentium and things like that. So there are ways in which they think about laws that are sort of common to groups, right? That aren't specific to us, and they'll do that occasionally when, say, a rule of Roman law conflicts with something that the king's courts are doing, right? There's no way you can reconcile these two things. They'll divide them up and say, well, that's a rule of the jus civile and that's a rule of the jus gentium. So it's still within kind of the Roman framework, right? And say, well, it's within a category that's recognized by Roman law. They also use custom in this way too, that there are interesting ways in which they play with custom and what custom is. Natural law, I'm not so, I would have to go back and I would have to go back and do some more thorough looking before I could say anything for certain whether they were thinking of this in natural law terms. I do think they think of Roman law and canon law is universal in some sense, right? That they see them as universal, but I'm not sure how closely they tied that notion to natural law. It's a good question.
So it seems to me that Dick Helmholtz has written about this somewhere. I mean, he's written about everything, right? But it seems to me that he's written somewhere that the common lawyers could often see that their work fit in nicely with natural law. So I can't help but wonder, did this go as far back as the 13th century? It would be interesting to think about.
That's a good question. Yeah, I'm not sure. Yeah, I'm not sure how closely they tied this notion to natural law. That would be an interesting. I just haven't looked into it.
Fernanda?
Hi, thanks very much. I really love the talk, but I'm a legal anthropologist rather than a legal historian, so I'm not at all of an expert in this area. But I was also just wondering whether I could push you a bit on what you think they thought the common law was. And you said you thought they wanted to push into the broader culture of the civil law. But do you think they imagined that, ultimately it was close enough to the civil law that eventually maybe lawyers would be citing Justinian or the glossators in the English common law courts? Or do you think they thought of it as having a sort of being a distinct, as it were, subspecies of law that was now following its own path and sort of becoming its own species of law?
Yeah. So in terms of what they thought the common law was, one of the things that I talk about at the beginning of the book is that this really is the period before the common law was the common law. That people hadn't settled on common law as the universal term for this thing. They had different terms for what it was the king's courts did. And in a lot of ways, they probably thought about this as sort of the custom of the English king's courts or something like that. The Bracton authors call it the laws and customs of England, right? That's their way or English laws and customs, depending on which title you read, which manuscript. In terms of what they thought it was, I think they do treat it as a distinct subspecies. That I think they're thinking of it as a distinct subspecies of Roman law. They want to show that it fits into that broader, that it could be understood as part of that broader Roman law framework. But they really don't seem to be that interested in reforming or citing Justinian in court. You find on Bracton's rolls, you find Roman law tags, right? Things like he uses Roman law phrases on his rolls, and he does actually. At one point, there is a point where he gets involved in a. He's the judge. He's the judge appointed to hear a special assize, and he gets overturned by the judges of the Court Quorum Rege, and he seems to be angry because they didn't apply the proper rule of Roman law, right? So it's a case where you probably could have gone either way, right? That there wasn't really an established principle on this, but you might think of it as a gap filler in that case. He doesn't cite to he doesn't cite to Justinian on his roll or anything like that, but he essentially says, like, look, this should have been a failed gift, and the principle that he applies is a Roman law principle. So I think there is a sense in which Bracton thought there was a certain type of learning you should have as a royal justice, and I'm not even necessarily sure he would have thought of that as just a rule of Roman law. This might get back to Sarah's point. That's just good law, right? That this gift should have failed because that's just good law, right? That's what it is. We learned that. I learned this in the law school.
Paul? Oh. Paul, did you have your hand up, or am I?
To unmute myself. Show myself. Tom, marvelous as always. It was, as you were talking in questioning, however, I was thinking again how much they think of themselves, I think, almost as an elite group within the royal justices.
Yes.
They're not citing stuff from other royal justices.
Right.
And if they did have a program, they don't seem to have understood that if you have a program like that, you've got to get other people opted into it as well. So whatever vision they had of it, they didn't have enough of the politics to go with a vision to actually carry it through.
I think that's probably, like, and now that you say it like that, I mean, this sort of sounds like academics, right? The vision, but no politics to carry it through. But I think Yeah, well, Bracton in particular is a good example of somebody who doesn't seem to have played politics as well as he could have, right? Yeah, that he's a royal justice. He never quite makes it to the top. He's always respected. He comes high on the precedence lists, and yet when even when the chief justice position in the court quorum rege is vacant, they don't appoint him, even though he's the next in line, right? And that sort of thing. So he makes it very close to the top, but never quite gets there, And that it might just be a certain amount of ineptitude politically. They also seem. They mostly cite each other, although you do have Stephen of Seagrave gets cited in the treatise, and some of the cases in the notebook, the last group of cases in the notebook, are from terms where Seagrave was sitting on the court quorum rege. And there were a couple of other justices they seem to have respected, despite the fact that they don't seem to have been part of this sort of in group, right? They followed different career paths. They don't seem to have been people who came out of the schools. They came out of service as under sheriffs or sheriffs or something like that. And so they seem to have played well with other types of justices. But I think you're right. They probably did see themselves as sort of an elite and never quite managed to play politics well enough to get this vision adopted.
Yep. Thanks.
Do we have any additional questions? Oh, John?
Yeah, this is sort of foolish follow-up to Paul's question, which is, if it's a matter of display and showing off and so on, and if they're seeing themselves as jurists and the heirs of Orpian and so on, and they know about Atzo, why is it anonymous?
Yeah, so this I find really fascinating. I found this in a couple of texts. I actually have started to think there might have been some kind of convention that developed in the royal courts, and I mean, if Bracton's that sort of, I don't know if it would have developed by Bracton's time, but there are a lot of the texts that appear, especially later in the 13th century, are anonymous. They do not tell you who the author is, but they have these convention. They often seem to have some way of telling you who the author was. So actually, Paul Brand is the person who's done work on this, but that Henry of Bracton's name appears in the treatise in the section on mistakes and writs. And Paul had pointed out that it's entirely possible that it might have originally said Martin of Padishal there, because it for various reasons, but it seems to that may have been changed at some point. So there's sort of a nod to Henry of Bracton. Paul has also written about Hengham Magna, right, which did eventually pick up the attribution to Hengham, but also has a similar sort of thing in it, where it has the name of a senior chancery clerk in the case. In some copies of it anyway, have the name of his senior chancery clerk in the not hypothetical case, but it was the actual case, but the case that sort of runs throughout as a sample case. There are other examples like that where it seems like the probable author of the text has inserted his name as some sort of character in the text, but has not actually set his name at the top. And I've wondered about this, and I wonder if there was some kind of convention within those circles that maybe it was a small enough group that everyone knew, right? Everyone knew who the author of this text was, and there was some sort of mock humility or something. You weren't supposed to put your name at the top. But that it is an interesting question, and I don't know why all these texts are anonymous, but then have these sort of like have these strange references to the author somewhere in the text. It's like paintings where the artist paints a self-portrait somewhere in the corner or something like that.
Do we have any other questions? I will actually ask one more myself, if you don't mind. I was curious. Oh, Am I not
Sorry, I
seeing
think
one?
Paul Himes was trying to raise his hand a second ago.
Oh,
So,
I must have missed
I
that.
saw his hand.
Paul?
Are you there, Paul?
Well, Paul, if you do have a question, please feel free to just interrupt me, but I will go ahead and jump in then in the interim. I did just want to ask about how you discuss the plea roles acting in the same capacity as jurist opinions. A bit of a chicken and an egg question. Did you see, or would you say that this view of the plea roles would have influenced the structural development of the roles themselves over the 13th century? Or I guess to put it another way, would they have evolved to reflect that position, or just kind of derived from the way that they were already being created?
I think you see that in Bratton's roles, that Bratton is writing his roles differently because he wants people to read them in a particular way. I don't know that they are getting longer throughout over the course of the 13th century anyway, and contain more detail and things like that. But I think you see Bratton actually including things that he means to be including bits that he intends for instruction, right? That he thinks people will read this so that they can learn this point of law and that kind of thing.
Can I have a go? Can you hear me?
Go for it, Paul.
Oh, yes.
I can hear you.
Slightly less competent at Bracton than I am at Teams, but 1258-9, the provisions of Westminster leading on to the Statute of Marlborough, there must be some connection, one way or the other, with the group of lawyers who did the thinking and presumably arguing behind the scenes. Have you worked on this, or has Paul Brown perhaps?
I have not worked on this. I mean, Bratton does seem to do well during the troubles of the 1250s and 1260s. He's appointed on the special assize commissions, both during and after the Civil War. So I mean, my sense of Bratton is that he's somebody who is who's respected by both sides, and who kind of manages to weather that whole period without going. So maybe he's not as politically inept as I thought he was, but he makes it through the early 1260s seemingly unscathed. So it's possible. I mean, it's possible that Bratton was a legal advisor for some of that.
Brand, if he's allowed a brief word here, says no, there's not really any evidence, I think, for that kind of connection. It would be lovely to know who the lawyers were who were helping the drafting of legislation. But the evidence just isn't there. A bit later, yes. 1270s, 1280s, no difficulties at all in seeing the justices being involved in doing things. I think it's the justices who are most likely involved in the actual drafting of legislation, though not necessarily in the formulation of the ideas behind it.
It would have to come out of a study of the ideas in Bratton's judgments, the times when he took a position one side or another of something that was controversial, and trying to work on the ideology that lies behind the provisions of Westminster. And I couldn't do this, but you probably could.
I'm not sure I'm going to, though.
Well, any other additional points or questions before we wrap up? All right, if not, I just wanted to say thank you so very much, Tom, for an absolutely fantastic presentation. Very, very enjoyable. And to all of our participants as well for their questions and contributions. This is our last seminar of term, and we will be back in Michaelmas term, but in the interim, we will hopefully be putting up some of our videos, some of our recordings as videos online, and perhaps some additional activities. So please do watch this space. Oh, that was a fantastic picture of William and Mary, I think it was. So thank you so much, everybody. No. Thank you so much, everybody, and we look forward to seeing you again soon.
Thanks so much, everyone. Thanks for the questions and conversation.
Goodbye.
Good to see you, Paul.
And you, Tom.